Hello, I'm Dr. Chris Rapoff of EZ QME Continuing Education, and welcome to this week's Case Law Update. In the Tayros versus City of Greenfield, the defendant sought reconsideration of the workers' compensation judge's decision. This time, the defendant alleges that the insurance company is not responsible for an advance payment to the QME for a minimum of 2 hours for their deposition. Initially, this reconsideration request sounds like a non-starter, but in this case, there were other circumstances to consider. So let's take a look. First, an introduction and the statement of the material facts of this case. Here the defendant petitions for the removal of the findings and order of an August 22 decision. And they're arguing that it should be allowed to take the deposition of a QME without first advancing him the payment of the minimum of 2 hours testimony for a medical legal expert, because they previously paid him the fee for a prior aborted deposition. That's where the contention is. Now, this is a claim that was denied in its entirety by the defendant, and it was an accountant for the city of Greenfield, had CT injuries or orthopedic injuries. Interestingly, though, the issue for the trial was whether the QME could be compelled to submit to a deposition by the defendant without the defendant making payment in advance of the 2-hour minimum expert witness fee under Title 8 of the California Code of Regulations 9785. Initially, the work comp judge ruled that the defendant could take the doctor's deposition, but it was required to advance the doctor the prescribed $910 fee, the $455 per hour times 2. The defendant initially scheduled the doctor's deposition in September of 2021. However, they contend that the doctor did not appear and the deposition was terminated after the parties waited 30 minutes. The deposition was then rescheduled for May of 22, and this is where the contention comes in. So in May of 2022, the QME appeared and was sworn in by the court reporter and briefly testified. The QME acknowledged that he did receive a payment of $910 for the September 21 deposition, but he did not testify. And his reasoning was that he stated that he spent 1 hour preparing for the September deposition and tried numerous times unsuccessfully to connect with someone at the number provided by the defense counsel, ultimately leaving a voicemail explaining these circumstances, and then waited another 30 to 40 minutes for someone to return his voicemail or to somehow contact him, but it never happened. The QME went on to say that he believed he was entitled to the payment of the additional 2 hours of time as a condition to proceeding with the deposition in May of 22. So he received the $910 initially for the first QME deposition. However, it did not take place due to an error by the defense. And now he is requesting a payment again in May of 22. Okay, let's get into the weeds a little bit. Labor Code 5710 and one of the codes of the Civil Procedure, a CCP, requires that the party taking a deposition of an expert witness pays the fee in advance for an anticipated time of the deposition or pays it at the start of a deposition. Title 8 of the California Code of Regulations 9795 states that the medical legal witness is entitled to be paid a minimum of 2 hours, which we know, and an hourly rate of $455 per hour. It also provides that the physician shall be entitled to fees for all itemized reasonable time spent related to the testimony, which includes reasonable preparation and travel time. We know that as well. The work comp judge stated that the defendant initially complied with these requirements by paying the QME the minimum 2 hours compensation in advance of the original deposition date of September of 2021. However, this is where it gets interesting. The defendant contends that it does not owe the QME the additional $910 for the rescheduled deposition, in addition to its prior payment to him, by arguing that the Title 8 of the California Code of Regulation, CCR 9793I, defines, quote, a medical legal testimony as a testimony at a deposition, further stating that the QME just didn't testify, so it's not owed. I think you can imagine what the response was by the Work Comp Appeals Board. They state that, quote, the argument is ludicrous. And first, it ignores the law's allowance of all expenses reasonably incurred by the expert witness in connection with the deposition, including prep time. We discussed that. But secondly, the defendant's argument does not envision any circumstance, zero, which an expert witness is entitled to be compensated when the witness doesn't actually give his testimony. So they continue by saying that, okay, theoretically, a defendant could deny payment even if an attorney cancels the deposition at the last minute or some other event not caused by the witness prevents his testimony. Here, the QME's testimony as to his time spent and the technical difficulties that prevented his testimony in the original deposition stands unrebutted and is convincing on the QME's part. So therefore, the Work Comp Appeals Board, that isn't the final extent of this ruling if you choose to read this case with the link provided. In addition to contesting the deposition fee, the defendant says, well, as a result of this, they requested that the QME be removed from the case as a result. The Workers' Compensation Appeals Board didn't take the defendant's request lightly, and they stated in their own terms, removal is an extraordinary remedy rarely exercised by the Appeals Board, and they will grant removal only if the petitioner shows that substantial prejudice or irreparable harm will result if the removal is not granted. Now, with that said, the Appeals Board contended that the defense did not explain how the challenge decision will cause a substantial prejudice or irreparable harm, or why the reconsideration of the ruling would not be an appropriate remedy. So the Workers' Compensation Appeals Board finally stated that there was no significant prejudice or irreparable harm to the defendant. So in conclusion, we have a case where the defendant, the insurance company, spent a lot of time and resources to deny a $910 payment to the QME. And in the interim, they also made a substantial effort to have the QME removed from the case for reasons we're not fully aware of. But just think of the billable hours that were charged for this request for reconsideration. This reminds me of the expression, spending a dollar chasing a dime. It comes to mind, but that's just my opinion. But I hope that you are prepared if and when this happens to you in the future, and be confident that you will prevail. Once again, doctors, hope you enjoyed this presentation. It seems to validate the good work that we are doing as QMEs and as we strive to provide the best, the most accurate QME reports in the industry. I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time to join me in this presentation. I hope you enjoyed it, and I look forward to sharing other interesting cases with you again soon. Until then, take care.